Hello everyone, good afternoon and welcome to another session on asset litigation. My name is Oluwatosin Isaac, and as is our due process or daily routine, we are here again to bring you another interesting topic to discuss and help you get enlightened on legal related matters. Now, if you've been following us from when we started this series, Understanding the Court System, you will see that we've started a series. It's a series, and today is the final. Yes, today is the final. So, we'll be looking at the courts. We'll be looking at different hierarchies of courts, and we've been explaining and establishing their jurisdiction, their history, how they started, the types of matters that should be taken there. You understand? For you to understand the structure of the courts, to tell you that you cannot just institute any matter anywhere in the courts. Imagine having a case and you say you're going to the Supreme Court, that you want the Supreme Court to hear your matter. that that is not possible. There are some things that are not even possible. So these are the things you should know, and we've been bringing to your notice how this court system operates. And today we'll be treating the final highest court. You guys are 2009, right? You know what I'm talking about, the Supreme Court. We started from the magistrates, we saw state high courts, we saw federal high courts, we saw court of appeal, and now we're looking at the Supreme Court. Yeah, I know the Supreme Court is popular. Everybody knows the Supreme Court. Yeah, the Supreme Court is like the Babanla of all the courts. Yes, the Supreme Court is the apex court, is the highest court in the land, is the final court. Whatever case is, I have a friend that says whatever case is taken in the Supreme Court, and you are not still satisfied with the judgment, guy, it's God that can settle you. It's God, oh, just appeal it to God. Take it to God, because that is the final court. That is the final court of appeal. That is the final. This is the last court of the last resort. If you have been instituting a case from the magistrate court, and magistrate court gave you judgment, you are not pleased. Okay, your right to appeal. Definitely, you have a right to appeal. You go to the state high courts. You go to the high courts. You go to the court of appeal, until it gets to the Supreme Court. Wow. And it gets to the Supreme Court and you're like, no, you're not still pleased with the judgment. Ha! Anyways, so I said the Supreme Court is the apex court in Nigeria. It is the highest court in hierarchy. It is the last court, court of last resort for appeal between parties. So it means that whatever decision the courts reach, whatever decision the courts arrive at, it is final and it is binding. No other court can overturn or change the decision of the Supreme Court. So that's just like the introduction. One thing you know about the Supreme Court, that the Supreme Court has two jurisdictions. I think I remember explaining when we were laying the foundation of the court system. I was establishing something. I defined what jurisdiction is, and I said jurisdiction is that power of the court to adjudicate on a matter, the authority the court has to adjudicate on a matter. So when we say the Supreme Court has original and appellate jurisdiction, it means that they have original authority on some cases and they have appellate authority. What do I mean? Original being that, when I mean original jurisdiction, I mean that there are some cases you start afresh. It's only Supreme Court you can start afresh. Do you understand? Remember I told you that Supreme Court is more like the final court of appeal. Like you are appealing your case, you're appealing your case until you get to the Supreme Court. Now, when you are bringing a case from maybe the High Court or the Federal Court or the High Court of FCT, you understand? And you are bringing it to the Supreme Court. You bringing that case, the Supreme Court has appellate jurisdiction. That's what we call appellate jurisdiction. It's more like hearing your appeal. The Supreme Court hearing your appeal. Original jurisdiction is the fact that cases that you can start afresh in the Supreme Court. So what are those kind of cases that it is only Supreme Court that can hear that case? If you are starting a case afresh in the Supreme Court, then it means Supreme Court is the only, like, the original jurisdiction of the Supreme Court. Only the Supreme Court has the jurisdiction to entertain such matter. So I've explained the original, appellate. So what are those instances where the Supreme Court has original jurisdiction? What kind of cases can you institute at the first instance in the Supreme Court? Cases between the states and the federation. Or Lagos State is fighting with federal government in Supreme Court. Two states of the federation, Lagos State and Ogun State, they are quarreling. Supreme Court. The National Assembly and the President. National Assembly is suing the President. Supreme Court. National Assembly and the State House of Assembly. Supreme Court. National Assembly and the States of the Federation. Supreme Court. So these are the cases. So you see that it's not even your regular theft case, because the Supreme Court has a lot of cases. So you cannot come to the Supreme Court and come and waste the time of the court. It's not possible. You can't come to the court and waste the time of the court. The Supreme Court is the highest court. So whatever case you are bringing, it means it must have every right, every authority to adjudicate on it. So if you have a case of theft, you can't bring it to the Supreme Court and say, because it's the Supreme Court, I believe in the Supreme Court, I believe there's justice in the Supreme Court. Who told you there's no justice in the other courts? Who told you that? There's justice, there's justice in the court. So if you have grievances that need to be addressed, you are seeking justice, go to the appropriate court. When you are not pleased, you appeal. Now, we've seen the cases that the Supreme Court has original jurisdiction. I will come again. The states and the federation, in any case between the state and the federation, between two states of the federation, between the National Assembly and the President, between the National Assembly and State House of Assembly, and between the National Assembly and the states of the federation. You can institute it afresh in the Supreme Court. Then I've explained appellate jurisdiction. Appellate jurisdiction are cases that are brought from the Court of Appeal to the Supreme Court. So that's Supreme Court having appellate jurisdiction. So that appellate jurisdiction is just like a supervisory role. The Supreme Court is playing a supervisory role, like a big brother. You understand? Like, okay, I went to the Court of Appeal, I'm not pleased with the judgment. Big brother, hear this out. Or Egbon, as we normally say in Yoruba, hear this case, so you understand? So hear this case and see what your younger one said. Is it right? You know, that kind of scenario. That is just supervisory role, checks and balances, so that there can't be any abuse of power or abuse of process or injustice, any record of injustice. So that is why the Supreme Court has appellate jurisdiction. I've also said it that the decisions of the Supreme Court are binding on parties, but there is also more. Yes, when the Supreme Court makes a decision, I said it is binding on parties. It is final. Final. If you are not pleased, come to God. You understand? So the Supreme Court is the final court. However, aside from the fact that the decisions are binding on parties, the decision of the Supreme Court also acts as a decision that other lower courts can stand and rely upon. We call it stare decisis in law. It's a Latin maxim. It's called stare decisis. It means to stand by things decided. So it means that when a court faces a legal argument, if a previous court has ruled on the same or a closely related issue, then the court will make their decision in alignment with the previous court decision. What it is just saying is this: Supreme Court decision. Let me understand. A minute. What I'm saying is this: Supreme Court decision, their pronouncement forms stare decisis on that issue. So other courts can, if there is a case going, if there's maybe, okay, let me just say an instance. The High Court is actually trying to decide whether a party has a local standard or not. that is, if a party is eligible, if he has the right standing before the court. And there are arguments between counsels here and there. Hey, blah, 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 blah. Every counsel can rely on standby. A counsel, a lawyer, or even the judge, when he's making his judgments, can rely on that decision of the Supreme Court. Why? Because the Supreme Court is higher. The Supreme Court is higher. Even if a High Court makes a decision on it, it gave a pronouncement, and okay, fine, it said, okay, President has to get right standing for courts. Let's say, for instance, he has to be a party to the suit. The High Court says so. And Supreme Court say, no, it's not like this. That whose decision will whose decision will be followed? That of the Supreme Court. It takes precedence. Why? Because it's a High Court. So what I mean that Supreme Court's decision forms, or Supreme Court's pronouncement forms stare decisis, means that the decision of the Supreme Court can be relied upon when there is an argument and they need clarification, or they want to base the argument on something, on like an anchor. Okay, you are saying this. According in the case of so and so, the Supreme Court held. You understand? So once the Supreme Court held, wow, that's an authority. It's a judicial authority we can rely on. So also the pronouncements of the Supreme Court are used for these instances. So what else are we going to look at? Let's look at the structure, the justices. Yes, our lordship in the Supreme Court. So according to the Constitution, there will be no more than 21 justices of the Supreme Court. There are no more than 21 justices of the Supreme Court. Of course, there is the justice of the Supreme Court. There is the justice of the Supreme Court, but there are other justices. And to qualify as a justice, there is a Chief Justice and there are justices. So when you are hearing a case, in the Supreme Court, it's not just one. It's not just the justice, the Chief Justice that will just sit and be like, no. There will be justices with the Chief Justice. So there are always 7 when it's in the original jurisdiction, when they're acting in the original jurisdiction, and 5 justices when it's an appellate case. You understand? So like that. To qualify as a Supreme Court justice, you must have been a legal practitioner that have practiced for nothing less than 15 years. Yeah, 15 years. 15 years. So to be a justice, you are appointed by the President on the recommendation of the National Judicial Council, subject to the approval of the Senate. Yes, subject to the approval of the Senate. That is how justices are appointed. The President appoints them. They are recommended by the NJC. The President makes his appointments and the Senate approves. So note that the Supreme Court is headed by the Chief Justice of Nigeria. However, it's not the Chief Justice of Nigeria alone that adjudicates on the matter. There are other justices depending on whatever jurisdiction the court is sitting. Be it original, there will be 7 justices. Be it appellate, there will be 5 justices. So that is all I can say briefly on the Supreme Court. That's what I can say briefly on the Supreme Court. I hope you know that we don't have judicial divisions of Supreme Courts. We just have one Supreme Court in Nigeria, and it's located in Abuja. It's located in Abuja, somewhere around that 3-arm zone. Yeah, I've been there. Very big place. Very big place. So that's the Supreme Court, and just one Supreme Court in Nigeria. That is why we try as much as possible to ensure that parties settle out of court. So that it will not get to a case whereby parties will keep appealing and appealing and appealing until it gets to the Supreme Court. Why? Are you telling me that you are not pleased with the judgment of the High Court or the Court of Appeal? The best every lawyer should do, in fact, a good lawyer will advise his client to settle out of court. Of course, for cases that can be settled out of court. it's still subject to the circumstances of that case. Something like a rape case, now you cannot say you want to settle down out of court. No way. So, we advise lawyers to tell their clients, to advise their clients to settle out of court. But when you get to a stage whereby only the courts can settle, then we go to court. The Supreme Court is just one, and to avoid clogging of cases, of case file, ADR is much more emphasized in Nigeria. ADR, we can use arbitration, we can use mediation, we can use negotiation. So until next time that we'll meet, until our next interesting session on accident litigation, I want you guys to like the video, I want you to share, I want you to ask questions, I want you to drop comments. Or if you have any contribution, or you have experience, probably you've been to the Supreme Court, you've experienced a sitting, how was it? How was your experience at the Supreme Court? Have you ever been to the Supreme Court? How was it? Was it different from other courts? Was it different from the lower courts? Because the Supreme Court is the federal court. So what was your experience like? Was there any difference? Of course there will be difference. Lots of difference. But all the same, tell us your experience. Leave a comment, share, like, and don't forget to join us next week as we bring another interesting topic. So until same time next week, 2 p.m. Thursday, I still remain Oluwatosin, and it is bye for now.